Good afternoon. This is the Governor's Committee on People with Disabilities, Accessibility, and Disability Policy webinar series. Today we have with us Erin McCullough, who will talk about Title I of the Americans with Disabilities Act and Reasonable Accommodation requests, and what's happening with the ADA these days as it's turned 29 years old. So Erin, I'm going to go ahead and move to the next slide and take it over.
Well, hi. Thank you for inviting me to speak. This is a re-report of a session that we had conducted back in October. And in addition, if you can move to the next slide, please. I am a substitute for the author of this presentation and the original presenter, Joe Bontke. Joe passed away in early October, October 9th of this year, shortly before this presentation was due to go live. Joe was a long-term, near 20-year employee of the EEOC. He had been a really valued colleague, and to me, he's someone who had worked with my former employers at the Southwest ADAAA Center, I think since inception until shortly before I started working there 20 years ago in December of 1999. While at that job, a lot of the interactions that I had with the business community and the public and the public sector always ask about Joe and how Joe was doing, and if Joe was available to help them. He had moved into private sector work before very shortly hiring on with the Equal Employment Opportunity Commission in Houston. Joe was a delightful person, a true believer in the promise of civil rights for people with disabilities, a great advocate for both the protections of people with disabilities in the workplace and then accessing the greater world that everybody else gets to. And in his role at the EEOC as an outreach coordinator and trainer, he was immensely effective and popular. And so I step into his shoes here hesitantly, but out of a great deal of respect for him and his beautiful family, who my heart goes out to. Again, he was a valued colleague and a loving friend, and he is missed. If you can, please forgive me, though I'm again walking in his mental footsteps here and working with his presentation and the notes that we had in reproducing his intent. But I also need to state that I am not an employee, as he was, of the EEOC. And to the extent that I depart from his message, that is editorial decisions made by me, I am using his content and following his the breadcrumbs of his presentation, but I am a private sector consultant. And while I have valued my professional relationship with the EEOC and seldom disagree with their positions, again, such departures are mine and should not reflect upon the agencies. The only significant alterations to this presentation is the addition of this memorial slide and the genericizing the content or the contact information for the EEOC, the Houston EEOC office on, I think, the last slide of this presentation, in light of the fact that regrettably Joe is no longer there to directly be contacted. So if you can advance to the next slide. The Equal Employment Opportunity Commission, or the EEOC, is charged with regulating in the arena of employment with regards to the protection of of people against discrimination in the workplace. They are focused on 8 protected categories of discrimination based on race, color, national origin, religion, disability, age for people who are 40 years and older, sex, and genetic information. In addition, floating all underneath these protected statuses or these protected categories are protection against the discrimination of retaliation, which we will get into with a little bit of depth later in the presentation. I want to touch just very briefly, although the focus of this presentation is primarily on disability, on some of the more recent movement that the EEOC has engaged in towards expanding the protections against sex-based discriminations to include sexual orientation and gender identity and transgender status. Certainly during the prior administration, the EEOC had followed I think the cultural wave and the wave of litigation, and in places led to towards the expansion of protections of the rights of employees who were members of the LGBT community. And to that end, in 2012, the Commission issued a decision statement that discrimination based on gender identity and transgendered status is and should be recognized under the Title VII provisions of the Civil Rights Act, and to be covered under sex-based discrimination based, again, on, I think, a logical extension and interpretation of the law, a series of related court cases, and I think the pulse of our evolving shared culture. In 2015, specifically following a case of Baldwin versus Department of Transportation, the Commission stated that, quote, "We conclude that sexual orientation is inherently a sex-based consideration," end quote. And an allegation of discrimination based on sexual orientation is necessarily an allegation of sex discrimination under Title VII. Again, this position follows an evolving strategic enforcement plan that the prior administration's leadership in the EEOC had developed and published in December of 2012 that specifically included the LGBT, or specifically including LGBT individuals under Title VII sex-based discrimination protections. Now, in October of this year, the U.S. Supreme Court had heard a number of related cases regarding the status of transgendered individuals and their protection under the provisions of Title VII. We await the publication of those decisions probably sometime in late spring or early summer, as these things take time to develop, as the negotiations within the architecture of the Supreme Court take place over the winter and early spring. So again, I think, while culturally these are not really open questions, and it will be interesting to see how this currently configured Supreme Court addresses these concerns. So if we can move forward to the next slide, we will get to the meat of the content, most of it related specifically to disability. But here I just want to get you an idea of the level of work that the EEOC undertakes and protecting workers against discrimination based on a wide variety of discriminatory or protected statuses or protected classes. You'll notice that Joe's slide has circled the number of charges brought in the U.S. during the fiscal year 2017, for there being 26,838 charges of discrimination based on disability, a total amount of charges of 84,254. Now, understand this is not reflective of the actual individual incidents of discrimination. Quite a bit of workplace discrimination takes place without the discriminated against party bringing a charge, or is resolved in-house, or is brought before a state or local authority and resolved or not at that level. Some of those cases are also brought into the federal level, but the EEOC's federal charges received in that year were 84,254. Now, we have, between the time this presentation was announced and now, we have had an updated figure and seen a slight downtick in the amount of disability-related charges in fiscal year 2018, so 24,605, but this is really a statistically very similar amount. Approximately 30 to 33% of all discrimination-based charges filed before the EEOC are related to disability, so not a not insignificant amount of cases, or rather charges that were brought to the EEOC on this very issue. So if you could advance the next slide, please. I want to give a little bit of background on the Americans with Disabilities Act. I suspect much of the audience is very aware of it, but the EEOC was, or rather the Americans with Disabilities Act, which includes protection against employment discrimination, was signed into law by then President George Herbert Walker Bush in the summer of 1990. But I ask you to kind of cast your mind back to what the world was like then. We were, the United States was ordered an invasion of Iraq after then Saddam Hussein had invaded our ally, the neighboring country of Kuwait. So Desert Shield and Desert Storm had began. Former labor activist, the Polish leader Lech Walesa became the president of Poland. The GM had launched its new brand of Saturn cars. The Simpsons had first aired as an independent show separate from the Tracy Ullman show, now nearly 30 seasons in. We were in the middle of we entered a major recession at the time, and South African activist Nelson Mandela was released from prison after 28 years. And Germany began its official demolition of the Berlin Wall in June of that year, shortly before the signing of the Americans with Disabilities Act, and the reunification of the country of Germany was truly underway. So again, I think this is kind of important just to place some context on this. In 1990, people with disabilities were finally protected in the same way that people of color and women and people who were born in other countries were protected after the passage of the 1964 Civil Rights Act. So the ADA was breathed into law, and regulations follow to, again, expand the promises of the Constitution to a large class of folks that had previously been lawfully discriminated against under most circumstances. So if you can flash forward to the next slide. Thank you very much, you have done so. There's a lot of myths and fears about disability and stereotypes that existed then and certainly do exist I think to a lesser degree, but still do exist now. A lot of irrational fears about the nature of disability. There are still folks that believe people with obvious disabilities have conditions that are contagious. People misinterpret physical disabilities for impacting someone's ability to think or to reason or care for themselves, when often that is not the case. There's also a little bit of a myth that there's not truly that many people with disabilities in this country, but in fact, the preamble to the Americans with Disabilities Act, the statement of Congress and upon authoring this bill to send to the president, clarified that there were over 50 million people with disabilities in 1990. And as of the 2010 census counts, there were 56 million or over 56 million people with disabilities who self-counted as individuals with disabilities in this country. There's a little bit of a mythology that the ADA's coverage is really overbroad, that it would cover any type of impairment and cover any type of perceived physical or intellectual or emotional difference. It is just not the case. And while the Americans with Disabilities Act is potentially available to cover everyone, if they are a person with a disability or become a person with a disability, it is defined under the law, and there's a great deal of regulatory guidance on what is a covered disability. But it doesn't cover the slightest impairment. It covers somebody with a significantly impacting impairment. Any number of other myths exist about about people with disabilities. Again, including that that they are unable to care for themselves, that they are unable to do their jobs, or unable to do many or most jobs. And in fact, many studies have shown that people with disabilities who are appropriately accommodated often tend to be very effective, and sometimes the most effective people, grateful for the work opportunity that they have been given. If you can move forward to the next slide. Understand, to give a little bit of history again, before the Americans with Disabilities Act, there was no widespread federal protection with people with disabilities. And while there were some states and localities that were leaders in recognizing the need to protect people with disabilities, there were any number of places where it was lawful to discriminate against people with disabilities, to do so openly and do so in a hostile manner. This patchwork of local and state solutions again was insufficient to provide the same sort of free mobility and access and participation in public life that people without disabilities are able to enjoy, thus necessitating some sort of federal solution. Specifically, many hotels and restaurants were not at all accessible to people with disabilities. Regrettably, this still remains the case. In many places, although there has been much obvious improvement in the intervening 29 years, there were far fewer curb cuts. There were literally places where someone with a mobility aid, such as a walker or a wheelchair, were stopped by the literal end of the sidewalk and the precipice of a curb when trying to cross a road to be a successful pedestrian in their own neighborhood or their own community, to engage in walking to work or walking to shopping. In addition, up into as late as the mid-50s in this country, there were state and local laws that we euphemistically call ugly laws, although I do believe there were some that were specifically referred to that way. These were laws that based on the fear and hostile stereotypes against people with disfiguring disabilities or disabilities that were perceived to be unpleasant to polite society, prohibited certain people with certain types of disabilities from even appearing in public during the light of day. In 1990 and before, people with disabilities were rarely seen in advertisements, rarely seen on TV shows. We've seen representation is vitally important for, I think, for very specific cultural reasons for people with disabilities, for people of color, for women to see examples of people like themselves portrayed in popular culture. I think from a marketing perspective, you should also, I think, agree that representing the potential customer base is critical in making people feel some sort of interest in and allegiance to your brand and product. Before the ADA, we rarely saw interpreters at public events to serve the needs of the deaf community. So they were precluded from accessing cultural events or participating in civic engagement, this critically important part of particularly local government, where the bang for the buck is in terms of the quality of life in your county or your city. There were few team sports for people with disabilities. There were few opportunities to engage in this kind of recreational competition that is valued by so much of us and is part of our cultural reality in this country. And again, since the passage of the ADA and the requirements, particularly of public sectors such as parks and recreation programs, to make their facilities and programs accessible, we've seen a wide array of growth in physical activities for people with disabilities, competitive wheelchair basketball teams, the somewhat recent Murder Ball documentary that showed the wheelchair rugby, the very competitive wheelchair rugby teams, where, by the way, the United States dominates in Paralympic, in that Paralympic sport. So it created a circumstance where the very discussion of disability was discouraged. The presence of people with disabilities were hidden and excluded. And that kind of isolation continues to perpetuate the type of discrimination that restricts people with disabilities from full participation in our shared public life. And so while the more obvious impacts of the ADA are the presence of wheelchair ramps and curb cuts and the requirement that people with disabilities be provided an opportunity to apply for and get and rise in the ranks of employment, another real impact is, again, that people with disabilities are becoming considerably more visible, and again, in our shared public life and our shared cultural awareness and within our media. If you can move to the next slide, thank you. The Americans with Disabilities Act was born out of a variety of movements: the disability rights movement, the independent living movements, the limited in scope success of the Rehabilitation Act and the amendments to that, which was a federal law that protected people with disabilities and had specific requirements for federal agencies and for people and for programs that received federal money. That law was passed in the 1970s and amended in I believe 1978 to give it more regulatory teeth or enforcement teeth. And you can really think of this as really the parent law to the Americans with Disabilities Act. What it did not do was to spread out the blanket of protection into the private sector. So private sector employees, or rather, were not protected by that law, and people with disabilities were not protected against discrimination and accessing the same public accommodations that people without disabilities were able to access, such as doctor's offices, tax accountants, shopping malls, restaurants, recreational facilities, etc. So those many of the same people who were involved in in crafting the Rehabilitation Act, were also involved in refining the creation of the movement and the documents that led to the passage of the ADA. The Americans with Disabilities Act, in its original version, was introduced into the federal legislature in 1988. Key names to think about as drivers and architects behind the Americans with Disabilities Act include my former boss's boss, my former director's direct supervisor was Lex Frieden. In addition, former Equal Employment Opportunity Commission Commissioner Kai Feldblum, who has very recently moved into the private sector, becoming a partner at the law firm Morgan Lewis. She was a long-serving member of the EEOC and a respected legal and civil rights mind. And again, she's moved into private sector work. I had the privilege of meeting her on the commissioner's tour several years ago. And again, just a remarkable person. Other notable folks were Patricia Wright and Marilyn Golden, Liz Savage, and the late Justin Dart Jr., Elizabeth Boggs, and many others. The ADA was redrafted many times and reintroduced to Congress. And at the time of its passage had been, I think, had been largely supported by by a very bipartisan group of legislatures, including a number of key senators, and the political press at the time described that opposition to the Americans with Disabilities Act in that period of 1988 to 1990 was pretty toxic. It was again a very popular and bipartisan supported piece of legislation that moved forward and was signed into law by a Republican president and amended by his son, or signed into law, and significant amendments to it signed into law by his son just 12 years ago. So if we move to the next slide, please. So why is this important? I think if you are a person with a disability, or let's say you were born a person with a disability, or you were early to becoming a person with a disability, the impact of the Americans with Disabilities Act and its importance is very clear. However, for people who don't perceive of themselves as a person with a disability, the reality of the circumstance is you may not have a disability now, but if you live long enough, you will become disabled. So the prevalence of disability absolutely escalates the older that you get. So the alternative to that is dying young and dying in a catastrophic manner very quickly. And as grim as that is, the reality is that age will bring with it disabilities. It's kind of obvious, but when you think about it like that, I think it should become clear why this was such a popular and again supported law in 1990. Age will bring with it a impact to your ability to hear or to hear very well. It will tend to blur your vision. It will tend to impact your mobility. So again, the longer you live, the higher your risk for these more general types of disability. But certainly the older that you get, the risk for specific disabilities, such as cardio and pulmonary disease and diabetes, is certainly higher. And these physical illnesses will tend to become, at least eventually, impactful enough to create a level of impairment that is a disability. So in addition, the longer that you live, the more opportunity that you have to experience serious injuries through you being an idiot and being a fault of your own, driving driving badly and ending up with orthopedic injuries or traumatic brain injuries, or because of other people's carelessness, negligence, or just accident of circumstance. The longer you live, the more likely you will, the higher your risk for becoming a person with a disability. And I don't mean to be so tongue-in-cheek about this. Disability is a reality for so many people, but for those people who it is not a reality for, it is certainly a risk. And I think that is an awareness that people should carry when they examine their commitment to preventing and not participating in the discrimination of people with disabilities. Because again, you stand a ever increasing risk of becoming a person with disability. If you can move to the next slide, please. We're going to briefly discuss the EEOC Strategic Enforcement Plan. So thank you for advancing that slide. Joe Bonke was spent a little bit of time in his presentation on this, and I'm actually pretty pleased. It gave me an opportunity to dig in again following his the breadcrumbs of his presentation and to review the thinking of this large federal civil rights law enforcement organization's approach to long-term enforcement strategies. So what is a strategic enforcement plan? Well, the EEOC is this large federal agency charged with enforcing various civil rights laws, and in doing so, creating a circumstance that will ideally reduce the amount of discrimination, prevent future discrimination by engaging in enforcement action, and where they can task their staff to remediating the specific incidences of discrimination in a strategic way to achieve that broader goal of a more inclusive and less discriminatory society. Therefore, they need to focus their resources on places where they believe it's going to have a great deal of impact. So as you might imagine, when you're looking at these 8 protected classes and this evolving, set of laws in a country of over 330 million people, with hundreds and hundreds of millions of employees and millions of employers, it's important to have a plan and use it as an anchor for future decision making. So the EEOC's strategic enforcement plan is a way to focus various departments within their agencies on their priorities in a way that effectively utilizes their staff and their budgets, and in a way that I think guides particularly the private sector in their response to this risk. So the EEOC provides a great deal of outreach, a great deal of training, a lot of technical compliance information on their website and through various other publications. And the EEOC is an effective litigator, reaching any number of settlements and winning any number of decisions in various arenas of workplace discrimination. And so the strategic enforcement plan is calculated, again, to best use those resources to best have their impact and on preventing discrimination. So if you can move to the next slide. The 2017-21 Strategic Enforcement Plan, was again a product of the prior administration. It was focused on eliminating barriers in recruitment and hiring, and protecting immigrant, migrant, and vulnerable workers, addressing emerging and developing employment discrimination issues, continuing the efforts of the EEOC on enforcing equal pay laws. This was a focus of not only the Obama administration, but the G.W. Bush administration, or the EEOC under that administration. And preserving access to the legal system to enforce your rights, and to a certain extent, I think um, uh, uh, at least examine the amount of forced arbitration agreements and employment that were and are still becoming common in employment circumstances, which is undoubtedly a rather one-sided power arrangement, with employers having a great deal more power over employees to push the potential enforcement actions against claims of discrimination out of the public view in the courts and into the a private sector, completely confidential and private arbitration circumstance. In addition, the EEOC's strategic enforcement plan again was focused on preventing harassment through systemic enforcement and targeted outreach. Now, understand that there has been an update as this new administration, now nearly 3 years in, has elected to refocus to a certain extent its major agencies, including the EEOC. They, absent from a 2018 update or a 2018 to 22 update strategic plan, not a strategic enforcement plan, but language in the earlier strategic enforcement plan that specifically included LGBT rights as a top level priority. That language is at least de-emphasized and in places absent from the updated strategic plan. And the current administration has clearly signaled that it intends to focus more on job growth, and has also signaled a commitment to more EEOC mediation. Now, it is not unusual for, particularly when there's been a party change and in the Oval Office, for there to be some pretty considerable changes into both the arenas of enforcement and the interest and commitment to particular levels of enforcement. I think there is no ambiguity that this is an administration that has a considerably diminished, and this is my editorializing, diminished commitment to the rights of people who self-identify as members of the LGBT community. But there also is no ambiguity that focusing on job growth and expanding a commitment to EEOC mediation, which might resolve workplace discrimination claims earlier and with less negative impact to both employees and employers, is a good thing. So I applaud this current administration's interest in job growth and their commitment to EEOC mediation. So if you can fast forward to the next slide, please. Additional focuses of the strategic enforcement plan are to eliminate barriers in recruitment and hiring, to focus on class-based recruitment and hiring practices, and to battle against exclusionary policies and practices, against channeling and steering workers, and segregating workers in the job place, engaging in restrictive application processes, including things that are inaccessible to people with disabilities, such as not making interpreters available, and using screening tools that will tend to disproportionately impact workers because of their protected status or their perception as a person, for example, with a disability. And we're going to talk about a couple of cases on that last point here as we move forward. Joe's notes include that there was a great deal of interest in the EEOC on focusing on this not at all new now, but certainly hugely impactful and growing tech industry, where there have been a number of charges of discrimination based on race and gender in a number of very large settlements. We'll talk about a couple of those. In addition, employment arenas such as law enforcement, which has long been an area where it's both important that we see representation of people with a wide variety of backgrounds and potential protected statuses. And again, these are, I guess, arenas of employment that are detailed within that strategic plan for EEOC interest. If you move the next slide, please. Another focus of the strategic enforcement plan was protecting immigrant, migrant, and vulnerable workers. Every EEOC district office was charged with identifying vulnerable and underserved workers within their locality, and those jobs and the focus for enforcement would be on preventing segregation, harassment, trafficking, pay theft, and inappropriately discriminatory pay practices, as well as retaliation for someone asserting their rights. For example, the Los Angeles District Office of the EEOC recently settled a sexual harassment lawsuit against Barraza, B-A-R-R-A-Z-A, Farm Services, and Bornt, B-O-R-N-T, and Sons, so Barraza Farm Services and Bornt and Sons, for $300,000. They settled a harassment suit brought by immigrant female farm workers. The facts of that case were that there was a farm manager who was alleged to have discriminated against contracted farm workers who were leered at and sexually assaulted. This manager was alleged to have groped the private areas of these female workers and engaged in other unwanted touching or sexual assault, which is what that is. And then firing 3 workers for rejecting these sexual assaults as what this person thought was a sexual advance. So rejecting this person's assaultive sexual advance. These workers, again, were brought this charge of sex-based discrimination and retaliation, and this and the LA office was able to secure, along with Defense Counsel, a $300,000 settlement to provide relief to the people who were discriminated against, as well as, again, other agreed upon remediation or in lieu of litigation, continued litigation. If you can flash forward to the next slide, please. In addition, and we're going to talk quite a bit about this, another emerging and important concern addressed in the strategic enforcement plan and something that has been of great interest to the EEOC is specifically issues regarding inflexible leave policy related to disability and workplace injury, so directly impacting the protections offered by the Americans with Disabilities Act. Specifically, the types of inflexible leave policies that fail the requirement of individualized assessment of a person's disability and of their request for reasonable accommodation. Again, this is part of a required interactive process where each case is looked at individually and not treated as a cookie cutter or hard line policy that will tend to create different impacts for people with disabilities, will tend to eliminate options and prevent full enjoyment of employment and promotion, et cetera. In addition, other concerns are the EEOC is looking at qualification standards and versus essential functions, and encouraging through litigation that proper job analysis and proper job descriptions are created so that, again, opportunities are not denied people with disabilities based on arbitrary or unrelated reasoning or poor analytical tools. So, for example, the EEOC brought a lawsuit on behalf of individuals with disabilities who work for the Hyatt Corporation. The Hyatt Corporation refused to let a front desk agent have the use of a chair at the front desk for no particular reason, for a policy reason. They failed to engage in an interactive process to assess the needs of this person who because of physical limitations, could not stand all day behind the desk. And so they failed to engage in a job analysis. They failed to establish that being able to stand and not sit at on a raised stool was an essential function of the job. And again, I do believe they settled that case in 2018 on behalf of the individual with a disability. If you can move forward to the next slide, please. For the last, I'd say 6 years or more, there's been an awareness of the Americans with Disabilities Act being used in combination with the PDA, or the Pregnancy Discrimination Act. So this is an emerging arena of law, or an emerging application of law in protecting the rights of women who are pregnant in the workplace. The EEOC again has shown a willingness to interpret the Americans with Disabilities Act, or the amendments to the Americans with Disabilities Act and the Pregnancy Discrimination Act, to protect women in the workplace against discrimination. So women affected by pregnancy or childbirth and related medical conditions to being pregnant or having given birth shall be treated the same for all employment-related purposes, including the receipt of benefits under fringe benefit programs, as other persons who are not affected or who are not pregnant or who have not been given birth. Given their, but similar in their ability or inability to work. So the EEOC has chosen to interpret this. So essentially, the Pregnancy Discrimination Act protects against very specific anti-discrimination, or protects against very specific discrimination based on pregnancies. You can't deny someone a job because they are pregnant or they may become pregnant arbitrarily. The Americans with Disabilities Act or the ADAAA Amendments Act protections kick in where there is a pregnancy-related impairment that significantly impacts an employee. So the ADA doesn't kick in under every circumstance because, pregnancy is a natural process. It is not inherently disabling. I think as defined under the ADA, and the courts have. But the courts have looked at this and in several circumstances ruled that, however, where under certain circumstances the pregnancy may create a situation where an employee will be impaired. So let's say, for example, where there are critical pregnancies that require limited activities to successfully bring a pregnancy to term and for a child to be born healthily. There are certain conditions that are much more common for women who are pregnant, such as pregnancy-related sciatica or even pregnancy-related carpal tunnel. Preeclampsia may create circumstances, and undoubtedly some women will experience any number of these pregnancy-related conditions in a less than impairing way, but any number of women will experience them in where the severity will be much more impactful and much more impairing. And so again, significant back pain, preeclampsia, gestational diabetes, etc., may differently impact somebody and make them a person with a disability as protected under the ADA Amendments Act. And so that person should be treated as a person with a disability and accommodated as a person with a disability conditionally. They should be treated that way so long as the impairment exists. So the expectation under most of these circumstances is that these will not be lifelong disabilities that flow from complications of pregnancies or difficult pregnancies or these common circumstances such as gestational diabetes, but that person should be treated as such and accommodated until such time as that is no longer an issue. And again, the EEOC has shown a great deal of interest in pursuing cases like that. If you can move to the next slide, please. So we're going to, the next section is really mainly just a bunch of specific case reviews, and we're going to try to hammer through that with some speed here. And again, following Joe Bonke's breadcrumbs here in his presentation, he has a great deal of notes in here, but they are pretty idiosyncratic. There's a focus on ensuring equal pay for protections for all workers, and particularly in ending any discrimination based on sex and the disparate amount of pay that women tend to receive in the same job titles in the same fields as men. So there's been a specific commitment, I think, from the EEOC through multiple administrations to pursue this, at least certainly in the last 20 years. So for example, in 2018, Uber, the technology company, technology and transportation company, settled with 56 workers to the tune of $1.9 million for sexual harassment and discrimination claims based on gender and race. Uber had agreed to pay 56 current and former employees almost $34,000 apiece to settle the gender discrimination and harassment and hostile work environment claims. The lawsuit was brought in October of 2017 by 3 Latina engineers, tech engineers, who alleged that they were paid less than their male and their white and their Asian male colleagues, and that Uber had used a system of employee evaluation called stack ranking that whose aim was to create some was aimed at actually establishing merit-based pay raises and advancement opportunities, but tended to create circumstances where women were discriminated against by men who preferred male colleagues. It created circumstances where people were siloed based on race. This has been one of those management evaluation methods that may have been effective when introduced in the company that it was introduced in, I believe, in one of the large manufacturers in the 80s. Again, a management approach that is becoming somewhat discredited as it's being applied outside of its particular kind of silo. The nature of employment, particularly in these vastly evolving and project-based tech companies.
I'm sorry, I'm going to have to interrupt, Aaron. I apologize. I had an internet window open I didn't know was open, and now I don't have a card. Just a second.
Okay, good. I'm gonna go get a glass of water. We pause?
Yes, we're pausing just for a moment.
Okay.
Sorry about that, audience. We'll be right back.
You there?
Yes, sir. We're ready when you are.
How are we doing on time here?
We're good. It's 3:42.
Okay, so I still need to pick up the pace on this one. So where did we close at?
30 minutes.
That I have 30 minutes left?
Yes, sir. It's
Okay.
we're on the ensuring equal pay protections for all workers, and I guess we were about to go to the next slide.
Okay, so I'll just conclude. Can you play back that last bit? Is that possible?
No, sir.
Okay, then let's just start recording now.
Okay.
So moving on to the next slide. A potential challenge moving forward for a lot of employees with disabilities is Walmart's elimination of their greeters program. It may, according to this slide and a number of news reports, generate any number of complaints about disability-based discrimination. So far, there have been, just in 2019, 3 complaints have been filed against a particular Walmart or particular Walmarts in Pennsylvania and Illinois and Wisconsin over Walmart's imposition of a then April deadline for phasing out greeters positions. So Walmart had hired any number of people with disabilities and older folks to be greeters in their stores. They had signaled an intent to eliminate these positions and to create what they call customer host positions. Walmart also indicated they would be inviting those employees whose jobs are being eliminated to apply for these positions. However, these new positions would have expanded duties, which might require holding ladders and lifting up to upwards of 25 pounds, engaging in many more physical activities than the Walmart greeters program employees had engaged in before. This is going to tend to absolutely eliminate any number of jobs for people who had held them successfully and loyally over time. So it remains to be seen how successful these charges will be if it moves into litigation. But again, I think we can expect to see any number of cases arise out of this as Walmart, the largest private sector employer in the country, makes a move that will again tend to shake any number of their employees with significant disabilities. If you can move on to the next slide. Another example, the EEOC is charged that a trucking company, one of the largest trucking companies in the country, CRST Expedited Inc., with discrimination when they refuse to hire a veteran with a disability. An otherwise qualified individual applying for employment with this company was denied an opportunity to be hired. In this case, the plaintiff was a Navy veteran who used a service dog to assist with his disability. And during the application process to the company, the veteran disclosed that he had a disability and that he used a service dog to help with his diagnosed post-traumatic stress disorder. The applicant successfully completed all the required commercial driver's license courses with a company that CRST partners with to create employees, but then was denied hire due to CRST's quote, no pet policy, failing to recognize that, again, a service animal is distinct from a pet. Such conduct would appear to violate the Americans with Disabilities Act. And again, the EEOC, on behalf of this individual, brought the case in 2017. They just settled the case in 2019. securing a $47,500 money verdict to the plaintiff and agreed to furnish other specific relief to settle this discrimination claim. Moving on to the next slide. I'm going to give you a quickie overview of the ADA and employment law under Title I of the ADA. Since we're jumping into any number of these cases, the Americans with Disabilities Act under Title I prohibits discrimination on the basis of having an actual disability, having a record of a disability, or being perceived as a person with a disability, whether or not you actually have an impairment that arises to a disability or not. Discrimination is basically a circumstance where someone is being disparately treated or retaliated against, which means they are a person with a disability is treated differently than employees or potential employees without disabilities. Discrimination is also retaliating against an individual who, say, for example, contacts their supervisor or the human resource department to complain about a failure to be accommodated or a failure a failure to be accommodated or otherwise discriminated against or harassed on the basis of disability. So if you, for example, let an employee go because they are a, quote, troublemaker when they raise a concern about a supervisor's inappropriate or harassing behavior based on disability, then that would be retaliatory conduct and potentially actionable under the ADA. The Americans with Disabilities Act under Title I, again, provides protections against discrimination, but it also requires, and I think this is the genius of Title I of the ADA, a reasonable accommodation for someone who actually has a disability or a record of a disability. And it's a reasonable accommodation to assist somebody with a disability to be able to perform successfully the essential functions of a job. This isn't to waive all the essential functions of a job, but again, to assist someone perform those functions of the job. So move on to the next slide. Specifically, again, discrimination is disparate treatment. Under the Americans with Disabilities Act, a disability is a condition that's both that is not both temporary and minor, however, an employee has to be able to perform their job satisfactorily or be an otherwise qualified individual with a disability to get a job. Disparate treatment may be evidenced by adverse employment actions, such as, again, the failure to hire a potential employee or discharge of an employee based on a disability, or discharge of an employee despite not reasonably accommodating them when a reasonable accommodation has been requested. So discriminatory disparate treatment also occurs when someone who's not disabled but is otherwise similarly situated. So let's say sharing the same work location, job titles, and job responsibilities, but that person is treated better. Let's say provided additional training opportunity, advanced within the agency, or provided additional pay despite similar performance levels and time in service. Now, again, it's not disparate impact to discipline an employee or to terminate someone's employment where there is a legitimate non-discriminatory reason to do so. So again, just because someone has a disability or lets you know that they have a disability or request a reasonable accommodation doesn't mean that you cannot fire an individual. Performance expectations, where reasonable, where fairly applied, are again reasonable parts of the management of employees. Now, this again doesn't protect an employer from discriminating against an employee with a disability based on ginned up or pretextual reasons, so made up reasons. that appear reasonable on their surface, but are again based on discriminatory beliefs. If we can move on to the next slide. I've mentioned this a couple of times. Wait a minute. So I might have gotten out of order here. Retaliation, there we go. Discrimination can also be retaliation. It's not just harassing behavior or failure to accommodate. Where an individual with a disability or other protected status engages in protected activity, they are protected against discrimination, and retaliation is a prohibited discriminatory activity. So, for example, where a person with a disability is asked for an accommodation or objected to discrimination in any other way, such as harassing language, you are prohibited. An employer is prohibited from retaliating against them based on that. Retaliation, again, would also be evidenced by someone who's subjected to what the slide here says, materially adverse employment action. So a demotion, a suspension, a pay cut, refusal to promote or train and enjoy other benefits of employment that other similarly situated employees can enjoy, or certainly dismissal. Retaliation, again, is a prohibited activity. To succeed in a charge of discrimination or of retaliation, the individual with the for example, with the individual with a disability would need to establish that the retaliation was related to their engagement in protected activities, such as, again, bringing a charge or filing a complaint or requesting an accommodation. And that they were retaliating against, and they would need to show a causal nexus. Again, this doesn't prohibit an employer from engaging in legitimate non-discriminatory employee discipline, employee demotion, or even terminating the employee for failing to live up to reasonable workplace standards. And again, pretextual reasons, those gender reasons are again prohibited. If you move on to the next slide, the Americans with Disabilities Act under Title I requires that employers provide this reasonable accommodation. I mentioned that I thought this was the genius of Title I. They must provide a reasonable accommodations to individuals who are disabled, unless the charging party cannot perform essential functions of the job, with or without the accommodation, and that would create an undue hardship for an employer. So what this means is, again, employers must provide, and employees have the right to a reasonable accommodation in the workplace to assist them in being able to perform the essential functions of the job. Now, we're going to talk a little bit about what specifically essential functions are, but very quickly, again, this is the reason that the job exists, those primary functions, not those other duties as assigned, or those very tertiary, reasons that an employee may exist, the occasional incidental or shared role purposes that everybody in an agency, for example, or a large private sector employer may be expected to incidentally do, but the reasons that the position exists. So employers are, again, required, and employees have the right to reasonable accommodations. If you can move on to the next slide, please. So how do you get to determining what a reasonable accommodation is? I mentioned before, but I'll say it again, whether the job exists to perform the function. What is the title of the position? What is that position traditionally done? If you're being hired as a salesperson at a retail counter and a small to mid-sized boutique store that's part of a chain, then your job is to conduct sales. sales. That would be inarguably an essential function of a sales job or a sales clerk job or a counter sales job at one of those retail sites. Another factor is whether there are others who can perform that function. Again, think of this as everybody in this shopping mall retail chain store are required to, quote, police the floor to make sure that the store is orderly, tidy, that the goods are arranged, that customers' trash is removed from the walkways, that weather-related water and dirt from the outside are identified, et cetera. Those are kind of shared duties, and the sales position, the counter salesperson's job wasn't created to do that. That's again potentially a job that all other people can perform. Another factor, but not the sole factor, is whether the job is specialized. Was a job title created and a person or a series of people hired to do specifically this one thing? I think this would best be exampled in kind of an extreme circumstance. You can imagine a highly specific technical job, a particular type of bench chemist or a machinist, highly skilled, multiple licensed, to who is hired to do a particular machine process or engaged in a particular type of research. Whether the job is so specialized, again, that its essential functions are defined by as much by the title in that very specialized specific role. Further evidence of whether something is whether a function of employment is an essential function. Employer judgment is considered, but again, it's not final or a complete set of a weighted factor, rather. The terms of a written job description that someone might read in front of making an application for a job, again, are factors, but not totally determinate factors. Specific terms of a collective bargaining agreement may be given weight in determining whether an essential function exists. Again, a union or other collective bargaining group may have hammered out particular details about employee titles and classes, and that may be given weight in determining whether a job function is essential or not. The amount of time that a particular employee or class of employers spend performing that function may be, again, a factor. The consequences of not performing the function, if this person is not able to do this function, what is its impact on the organization as a whole, or the processes that this business exists to engage in, or the products they engage to produce. And the experience of current and previous employers who are in this job or substantially similar jobs. Again, these are factors that you may consider. None of them are individually determinate factors. If we can move on to the next slide, please. So what is a reasonable workplace accommodation? A reasonable workplace accommodation is merely an adjustment or a change in how a person does their job in the workplace, and the way things that are customarily done by employees without disabilities. And again, these reasonable accommodations should be targeted to assist the individual with performing their essential functions. The accommodations are available or should be available for the application process, to enable someone to perform the essential functions of their jobs, and to enable an employee to enjoy all the equal benefits and privileges of employment, which may include things such as additional training, participation in national or in conferences and symposia, and these more external opportunities that may lead to advancements or higher pay or be considered other perks of employment that people without disabilities in those positions may be able to enjoy. We can move on to the next slide, please. Request for reasonable accommodations. Generally, a person with a disability will make the request for reasonable accommodations. They may request some change in how they do their job or to request assistance to perform their essential functions. That request may come at the beginning of their employment. It may become necessary as their medical condition changes or an identified disability's impact on that person changes over time. You can imagine, let's say, for example, someone with MS who has cyclical impacts of their disability on how they perform a job. So they may need to require that change in the middle of their employment. This request for reasonable accommodation does not need to be in writing. It does not have to use the magic words, "I am formally requesting a reasonable accommodation. I'm requesting my rights under the Americans with Disabilities Act." There are no specific words, but if they indicate clearly enough to their supervisors or human resources or someone else in management that they need some assistance to perform their job, that should be sufficient to put the employer on notice that the reasonable accommodations interactive process should be begun. This request may again, generally is going to come from the employee with a disability, but it may come from a third party, such as an employee's family member or a doctor or a union representative. You can move forward to the next slide. Most of the rest of this is going to be some case law. We're going to push through pretty quick. What about attendance as an essential function? In the case in the slide listed, Williams v. AT&T Mobility Services, a call center worker in Memphis who had a psychiatric disability that included anxiety attacks that were provoked by and worsened by stressful calls, was unable to show that she was able to perform her job. The employer maintained pretty strict attendance guidelines. The employee requested more flexibility. The actual nature of the job tended to worsen the symptoms of the employee's identified diagnoses and disability. The guidelines were identified at higher. The expectations for the role were detailed in the job description. These guidelines pre-existed the complaint that led to the litigation. The managers were able to convince the court why attendance was required in this particular role, and the plaintiff failed to prove their case that that they needed the type of flexibility and leave and specific accommodations around their disability, and that they could do the essential functions of the job that they were hired to do. Moving on to the next case. This case deals with type of accommodation. Under this set of circumstances, Hostetler versus the College of Worcester. The employee, Hostetler, was pregnant. She was hired as an HR generalist. She was diagnosed with severe postpartum depression. While she had disclosed her pregnancy at the time of hire, and she had disclosed her plans for maternity, she was hired. She was given 12 weeks of unpaid leave, even though under the FMLA, even though she was a new hire and had not had enough time in service to trigger her eligibility, but the employer had again hired her with this as a known concern and a known need. Following her leave, again, she experienced a severe post-pregnancy impact on her emotional state. The doctor cleared her to return to work, but initially on a part-time schedule, and this was anticipated to last for about 6 months and to gradually increase. Despite the fact that this new hire employee, or somewhat new hire employee, was able to get all of her identified tasks done while working in this part-time schedule, she was denied an opportunity to extend the gradual increase leave period, and the Sixth Circuit had determined that she was discriminated against, and that the employee had asserted her case, and that the defendant had failed to prove its case, in as much as although regular in-person attendance is an essential function of most jobs, it is not unconditionally so. That the employer should have done an individualized analysis, engaged in the interactive process, and considered, again, balanced their needs, the identification of the essential functions, the performance of the employee in this a limited schedule where she was successfully performing the tasks, and failing the employers doing that, the court must do that function, must engage in a specific analysis, and they did so, and again determined that the university had discriminated against this employee. Moving on to the next slide. So this is an emerging, kind of an emerging issue related to actual physical presence. The slide indicates that telework is a reasonable accommodation is the kind of theme of this. Under this set of circumstances, an in-house attorney had asked to work from home for 10 weeks while on bed rest for, again, complications due to pregnancy. The employer said that her physical presence was an essential function. The appeals court upheld the jury's verdict for the plaintiff, noting that while trying cases and deposing witnesses were within that attorney's job description, she had never done so in the previous 8 years for working for the employer. So while she was, again, could potentially be tasked to do that, she had never been done so. Her request for, again, a virtual presence or telework presence during her recovery would have allowed her to potentially perform the essential functions of her job, and that the hard denial and failure to accommodate her under those circumstances was a failure of the employer. The individual was awarded $92,000 in compensatory damages and over $18,000 in back pay for the employer, again making a hard cookie cutter decision versus being, again, I think respecting this individual's rights and doing individualized analysis. The next slide. So this deals with the timeliness of reasonable accommodation request. Under this set of circumstances, Guzman versus Brown County, the employer, despite the employee potentially having a disability, the individual asserts that she had sleep apnea, created sleep disturbance, and interfered with her ability to timely arrive at work. The employee was fired for tardiness. At the time that she was formally let go, somehow between the time it was decided to terminate her and she probably did her exit interview or interacted with human resources, she presented a doctor's note stating that she had sleep apnea, but there was no evidence that presented by the plaintiff that the employer had been put on notice for that she had this impairment that was disabling. And in fact, there'd been a prior fitness for duty exam that the individual had did not have an impairing level of sleep apnea. So the court determined that the employee had not proven the case, that the employer had not been put on notice, and that the request for kind of a remedial reasonable accommodation after someone had already been terminated was not timely. So we move on to the next slide. Or actually, and I'll just comment on that last case. Again, the time to request a reasonable accommodation is when you need it. I don't think, I think it should be logically clear that someone might have a legitimate disability and someone might not initially need a reasonable accommodation, but when it becomes clear that a person does, that person with a disability should request that reasonable accommodation and document that they've done so. An employer has is not expected to be a mind reader or otherwise invade the privacy of an employee. An employer may be hesitant to, but is free to discuss performance issues as they evolve, and maybe even suggest accommodations if there's that kind of opportunity or good relationship. But they're not obliged to do so. An employee with a disability has rights under the Americans with Disabilities Act, but they do need to assert them. So if we can move to the next slide, the EEOC versus Walgreens. This is one of those really bizarre cases. It's a little bit old. It's from 2014. This is a long-term and successful employee of the Walgreens company. Had worked for them for any number of years. The company for I think over 14 years was aware that this person had type 2 diabetes, and this individual this employee was experiencing a hypoglycemic event and was unable to clearly communicate how severely this was impacting them. So she basically snatched a bag of potato chips and ate them to level out her blood sugar, and was unable to communicate to the in-house loss prevention and security staff that this is what this was for, and had attempted to pay for it once her blood sugar had leveled out. She, however, was terminated for theft of a $1.39 bag of potato chips. So again, despite a note that she had written when she was experiencing this event that, quote, "my sugar was low, not have time," this was not considered. She was terminated. The court, or rather the settlement award was $180,000 and required that Walgreens revise their policies and improve their training on these very issues. And the circumstances that a valued employee with a good track record was let go, and the company had to engage in very expensive, difficult, and publicly embarrassing litigation that lost them a valued employee. If we move to the next slide. In this set of circumstances, the slide's title is "Indefinite Leave is Not Reasonable." The employee, Escobaria, had took a short-term disability leave for 5 months due to her psychiatric disability. She had requested 5 months leave. The employer had extended that leave multiple times. After she basically was advised to return to work or potentially lose her job, the employer is reported to have submitted a doctor's note that requested additional, presumably unpaid leave off. The court found that the employee had not established that the additional leave would enable her to return to work. At the conclusion of the leave, that they had not been able to reasonably establish that this would be accessible accommodation, and that the claim for additional 12 months or really indeterminate, potentially endless leave as a reasonable accommodation was not at all reasonable. So the employer was determined to have acted appropriately in terminating this employee. So the next case, Severson versus Heartland Woodcraft. The individual had a back condition, had requested FMLA leave, had been granted FMLA leave, but then had surgery on the last day of his leave, so the last day of potentially 12 weeks of leave, and then asked for an additional 2 to 3 months of leave. The court indicated that, and these are separate rights. The FMLA guarantees up to 12 weeks of potentially unpaid leave. There's a variety of ways that the FMLA is applied. A private sector employer may allow someone to take 2 weeks of their paid leave if they have it, and then allow them up to 12 weeks of unpaid leave, or they may lawfully just allow 12 weeks of unpaid leave or a mix. They may simultaneously toll the paid and unpaid leave. The Americans with Disabilities Act, reasonable accommodations might extend that leave under those circumstances, but the court determined that a multi-month additional leave, particularly given the facts that the person waited till the end of their FMLA requested leave to invoke the ADA, was unreasonable. And again, that the employer was sufficiently protected to terminate the employee. The next slide, please, is EEOC versus the UPS. In this case, this is another of a long line of cases where the EEOC takes a dim view of an employer that has a very inflexible leave policy. In this case, the EEOC alleged that UPS had a hard line rule where they would fire employees despite that employee being a person with a disability automatically when they had reached 12 months of leave without engaging in the required ADA interactive process. This led to a $2 million settlement for victims, a very expensive case that the UPS had to engage in and settle with. And the key here was that it was the inflexibility of the leave policy, as evidenced by the fact that there was an automatic trigger for it, and the EEOC's guidance or the Title I regulations and the EEOC guidance makes it abundantly clear that this needs to be an individualized assessment, that you need to engage in an interactive process, and that these kind of hardline rules that a certain behavior triggers an automatic termination are going to almost always be dimly viewed by both the EEOC and the courts. You can move on to the next slide. Another case about inflexible leave. The EEOC brought a case on behalf of disabled employees for this airlines, American Airlines, and a related Envoy Air, and asserting that that they had violated the ADA by requiring that their employees who return from medically related leave return with no restrictions, and that a policy that they had that an employee could not return with any restrictions would tend to discriminate against people with disabilities and barred them from returning. Again, it was the inflexibility of this return from leave policy under this circumstance that created a discriminatory, disparate impact on people with disabilities. So, for example, someone whose workplace injury created a lifelong disability led to them to take a leave and return recovered but still disabled. Their unwillingness again to consider reasonably accommodating some person upon their return from medical leave was determined to be discriminatory. The next slide. Again, a continuation of inflexibility in leave policy. Here, very similar to the last slide, the employer maintained a policy that employees had to be 100% healed, not headed, but 100% healed before returning to work. The suit alleged that that people with disabilities and people who have this record of this let's say medical leave or were discriminated against due to their disability. The consent decree that was entered into in late 2018 led to a payment of $3.5 million to compensate those victims. Again, a very expensive remedy to what should have been prevented in good workplace policy. The next case is EEOC versus Murphy Oil. Here you had a valued long-term employee who had a serious back impairment. They had visited a doctor, had identified workplace restrictions that were suggested, not really imposed, but suggested by the treating physicians, and the employer was aware of it. The employer failed to accommodate the employee with the disability, and the employee alleges that they were discriminated against when they asserted their rights in violations of the ADA protections against retaliation. So that case settled in 2018 and to the tune of $100,000. And the lesson that Joe indicates that you should take away from this is that failure to make adjustments for the manager's physical impairments resulted in a loss of a solid employee. And I will, again, point you to the line above, and $100,000. The next case is EEOC versus Associated Fresh Market. This is, again, a very large settlement, over $830,000, where qualified individuals with disabilities or other medical conditions were denied reasonable accommodations to perform their jobs because the employer required that they return from leave with no restrictions and with 100% ready to return to work. Exactly the kind of hardline rule that tends to be a violation of the ADA and tends to be dimly viewed by the EEOC and the courts when interpreting this law, resulting in a settlement of over $832,000. The next slide is a Coca-Cola case. Thank you for moving that forward. Here, there was a 2018 settlement from a lawsuit that was brought in 2015. Coca-Cola had to pay up over $2.2 million to settle their return to work policy that tended to discriminate against people with disabilities. Here, there were 9 individuals with a disability who brought disability-related discrimination charges, alleging that they weren't accommodated by their employers. This very large, internationally known employer conceded that this was the case, settled for $2.25 million, and agreed to update their policies and procedures to improve accommodations, and particularly related to employees who were returning to work after disability-related absences. In addition, they were required to establish a dedicated accommodation leave management team, which they should have had in front of this in front of this lawsuit, given the size of this organization, and to provide annual financial support to selected nonprofits dedicated to help people with disabilities. So, again, a successful outcome, but a preventable loss to this company's bottom line and reputation. We can move on to the next slide, please. This is a 2018 case, or it's a case that settled in 2018. It's the EEOC versus Home Depot. EEOC brought a case on behalf of an employee who had irritable bowel syndrome and fibromyalgia, a somewhat unrelated condition to this, to the nature of this case. The employee's IBS created a circumstance where they needed an emergency bathroom break. They were denied one, but rather than soil herself, she left her workstation to go to the bathroom, and she was fired for abandoning her workstation. Home Depot made no attempt to accommodate an employee with a known disability, and again ended up settling for $100,000 in August of 2018. Joe's lesson here is accommodation was reasonable. The accommodation was essentially free. And during the EEOC's investigation, the employer couldn't establish that there was an undue hardship for, again, allowing this individual who had a specific disability that that impacted their ability to stand there and not have a bathroom break. But I mean, as a general rule, Home Depot should have done a better job creating a policy that provided some flexibility for employees who have to stand all day long at the entrance of a larger retail facility open to the elements. And they might need to anticipate the needs for their hundreds of thousands of employees to potentially need to go to the bathroom on an emergency basis, and they failed to do so. Again, not acceptable for a smaller employee, absolutely unacceptable for an employee as large and experienced and as well-heeled as Home Depot. We can move on to the next slide, please. These are two cases regarded that essentially had the same backstory. EEOC versus Safeway and EEOC versus Jackson Food Stores. Both of these are cases where grocery stores refuse to accommodate an applicant with a disability who applied for a job through an online interface, requested a reasonable accommodation in the hiring process of an interpreter to help them during the interview process. And both of them were denied an opportunity to be provided an interpreter or some other means of effective communications so that they could have the same opportunity as other applicants without disabilities to apply for and potentially secure a job. Now, the Jackson's Food case settled in 2018. The EEOC versus Safeway case is, I believe, still a pending case. And that case, I think, is notable in as much as the applicant had provided guidance to the hiring staff on where they could secure adequate, effective, ASL interpreters. And they were basically told that they were basically told no. If we can move on to the next slide, please. This is an interesting case. It's a failure to hire based on predicting future disability. The EEOC brought this case on the behalf of a number of applicants who were disqualified from applying for a job for this manufacturer of steel casings for the railroad industry. This is a heavy equipment, heavy materials job. The employer subjected applicants to an external medical evaluation aimed at their claim that on protecting potential employees from work-related injuries. So they went to a third party who did a medical analysis to test for potential carpal tunnel through a nerve conduction test, and they denied any applicant who showed some tendency towards that. And their rationale was that they would have to use a piece of equipment that might have a significant negative impact on the physical health of someone who would do that job. The court, these applicants were denied based on this third party's test. The court ruled that the nerve conduction test was unlawful, that it wasn't, they didn't go so far, I believe, as call it junk science, but say it wasn't established science, that it was a good predictor of the risk of potential future disability, that the mere, and went on to state that the mere possibility of a small statistical risk of future disability was not sufficient enough to deny these prospective employees their shot at the job, and that the screening would tend to rule out people with disabilities or people who were there or who were perceived as having a disability. And so the EEOC entered into a successful consent decree settlement with the company to the tune of $4.4 million. Excuse me. Next slide, please. Okay. In closing, again, I just want you to recall that if you have any additional questions, I'm happy to answer those in the future. In addition, you can reach out on Twitter to the EEOC office in Houston that Joe Bonke worked at, and I provided you the EEOC Houston's Twitter handle. If you can move on to the next slide. In addition, a great resource is the Job Accommodation Network. The Job Accommodation Network is an enormously effective resource. It's a research institution based at, I believe, University of West Virginia. And their focus is on demystifying disability in the workplace, the reasonable accommodation process, I think the best thing they do is identify a lot of very specific ways to accommodate specific disability types, from psychiatric disabilities to specific orthopedic impairment to communication-related disabilities such as being deaf or hard of hearing, low vision, blindness, limited physical manual dexterity, and again, a wide variety of specific impairments and disability types and strategies to promote safe and effective reasonable accommodations for those folks, as well as a lot of great general research topics around accommodating employees with disabilities. They have a rich resource library on their website. They can be reached at these toll-free numbers. They do answer their emails, and apparently they have added a Job Accommodation Network consultants interface through Skype, which would be an interesting experience. I'm going to have to take advantage of that one myself. Again, this last beautiful picture of our friend Joe Bonke, and this is the generic contact information for the EEOC Houston office. The only thing I added to this slide, of course, Joe is missed. He will be missed. And I thank you guys for this opportunity to present. If you have any follow-up questions, please reach out to the EEOC or reach out to the Texas Governor's Office. I am happy to continue to answer questions on these topics. Randy, thank you.
Thank you, Aaron. And could you give us your email real quick? If people do want to contact you, it's in the transcript. Sure.
I use a Gmail address. It's j.aaron.mccullough@gmail.com. That's j.aaron.mccullough@gmail.com. And that's mccullough.
Let's try it one more time for Cart.
j.aaron.mccullough at gmail.com.
Perfect. Okay.
Thank you, folks.
Thank you, and thank you for anyone viewing the webinar. Please feel free to reach out to us at the Governor's Committee on People with Disabilities as well. I want to thank Texas Closed Captioning for the captioning services, and have a great rest of the day.